judicial service with obligation, which includes transferring judges, including Superior Court justices and judicial officers. It goes on, and then talks about the 3 alleged findings and recommendations for removing the Chief Justice from office by the Pwamang Committee are false, misleading, irrational, absurd, and perverse in the Wednesbury sense. Getting close to some of these anchors on the ground, it says the entire findings and grounds of the said Pwamang Committee are in violation of the applicant's constitutional rights contained in Article 19, 13, and 23 of the Constitution, and then a proceeding of the committee violated Articles 23, 296, 146.3, 146.7, and 295 of the Constitution are therefore illegal, void, and of no effect. And then finally, it says the entire proceedings of the said committee were conducted with substantive and fundamental procedures and unfair that renders the findings and recommendations Finality, Brace.
So those are the grounds on which she's basing this particular, action on. Now we know that she's also get all her entitlements.
Yes.
Tell us more about that. You mentioned earlier, but
yes, having been removed from office as Chief Justice, it would follow naturally that all her entitlements that was due her will be lost. For instance, if she retired as a Chief Justice, she would have been entitled to the salary of the Chief Justice until her death.
Okay.
And then there are other benefits, including and so if you look at some of the key reliefs she's seeking, she says she wants an order prohibiting the denial or withdrawal of the salary, 1, benefit, 2, courtesies, 3, and other entitlements, 4, that are due her before the warrant of removal that was dated the 1st of September 2025.
Now, we understand an action has already been undertaken. There's been an injunction application, and we don't know when this matter will come before a judge. Do you know anything about that?
So, if you look at this matter, and look at endorsement on it, to fix a date to be fixed, and court to be moved on, date to be fixed. So there's not a specific date that has been filed with respect to this matter.
Okay.
When it comes to also an application for injunction, we expect that perhaps in the coming days, we don't know what strategy she and her lawyers will adopt. Perhaps they will file a substantive injunction application. We know that Parliament will resume next week, Tuesday. When they do, on that day, we have gotten information that the Council of States have advised the President to appoint Justice Baffoe-Bonnie as the next Chief Justice. If that goes to Parliament, the Speaker will read that letter on Tuesday and then refer it to the Parliamentary Committee on Appointments. Then, in the next week or 2, the Parliament Committee will vet Justice Baffoe-Bonnie, who is currently acting Justice, and if he gets the approval of Parliament, sworn in by the President as Chief Justice. And so that means the Chief Justice may perhaps want to file a substantive injunction application and then get the court to hear it as early as possible prior to this, because in a line of cases, the courts have been very reluctant in terms of injuncting other arms of government from continuing some of those processes. But that is all up for the courts to decide if Madame Torkonoo files an action in the High Court.
This is still the top story. We've been joined on the line by Nia Ikoyotu, who is a former Attorney General and also a lead lawyer for the former Chief Justice before the Justice Pwamang Committee. I'm grateful to you, sir, for joining us here. Now, we understand Parliament will be convening somewhere next week. If an injunction is not sought and Parliament carries through with the vetting of the new CJ, will this case still have a leg to stand on?
Well, okay. Thanks for having me. I think we have spoken proficiently on this matter since the recommendations were made public, and then the President proceeded to act on it. I think the first judicial review we're seeking was directed at finding out whether the President acted properly by removing her and both a justice of the Supreme Court and justice of the Republic. What we have done this time is to attack the grounds which were used for removing her, and we're asking if it's released. As to where there's rule of law, at least when a case is sub judice, which means a matter is pending in court, we are all, in terms of respecting the separation of powers, not to interfere with the pendency of a matter which is before the courts, and a separate arm of government. So if the executive, both the executive and the legislature, wants to respect the judicial arm, if they want to stay their hand while the case is pending.
But has the injunction application itself been filed?
Well, you will see that there is a prohibition order being sought in this particular matter which has been filed, not necessarily an injunction.
But, so you're expecting Parliament to, based on this, to probably stay till this matter is heard?
In a country of rule of law, the three arms of government are equal, and they want to respect the boundaries of authority exercised by each of them. And therefore, one would have thought that when a matter is pending, both the president and the legislature would want to restrain themselves and hold on and allow the court to determine the matter. I produced a judicial review application, and when the state file, the parties can rely on the statements of faith, and the judge can then rule without necessarily taking evidence, which will take a very long time. So I mean, if they want to respect the boundaries of authority, I don't think anything, prevents them from doing that.
But one of your reliefs earlier, the Supreme Court said clearly that it's difficult to injunct one arm of government. What still gives you that assurance that this relief you are seeking for could probably be granted?
This is a major and a substantive matter. It is not an interlocutory. You are rather introducing the interlocutory aspect. So it is that interlocutory aspect that will be problematic if anything at all. But we have asked for a substantive order, not an interim order or interlocutory order.
But in this particular case, I mean, all the cases that, all the applications that the former Chief Justice has filed, the court has had issues. I mean, they've dealt with them. They've not really granted all of them. What is the Chief Justice actually looking for to still be fighting this?
You've seen the release, so I'm surprised you're asking me what he's looking for. What he's looking for are the grounds which are clearly stated that all the three grounds used in removing her are unreasonable, they are unfounded, they are not supported by the evidence on record, they are perverse. So, I mean, the grounds are well stated. So why are you asking me what is he looking for?
Because
you should know from reading it. And you had somebody who read everything to you before we came on to do this discussion.
I get it, yes.
Well, I'm sure you pretty well know.
Well, because, since this matter started, she has availed herself to the process. So someone will be asking, why avail yourself to the process and still challenge the process again at the end when the committee has come out with its findings?
Oh, thank you very much for asking that question. When you are given an opportunity to be heard and you stand that opportunity, what do you think you have done? Are you then turning around to say that the committee was unfair or that the committee failed to give you a hearing? So once the committee is set up and you are invited to appear, it's only fair that you appear yourself. Now, the question that you could ask yourself is this: does it mean that once the committee comes out with a recommendation, those recommendations cannot be challenged in a country where we practice the rule of law. Do you understand what I'm saying?
Perfectly.
So if she's challenging the grounds that have been used to, remove her, why are you asking what she's looking for? She's saying that the grounds are perverse. They are reasonable. They are not supported. I mean, how can a Chief Justice who is the head of a judiciary be told that if she transfers a worker, that amounts to a stated misbehavior? How can the committee come to the conclusion that when the Auditor General did not make any disallowance or surcharge against her, and she was not the spending officer, yet she should ultimately be held responsible for anything that had happened? I mean, you look at all the three grounds. How can you say that the Chief Justice, who is one of the constituencies for making recommendations for justice to be promoted or elevated to the Supreme Court, had made such a recommendation, and that amounts to stated misbehavior? So you look at the grounds that she's attacking and using to attack, and ask yourself whether there isn't much in what she's saying. There is everything for it, which any court is trying to do justice would be able and should be able to come to that conclusion that something horrible has happened, and that is the Chief Justice is entitled to the relief that she is seeking.
We've seen a Chief Justice that is trying to, some people have said, protect the institution she believes in. So if the court do not grant these reliefs, what is next for the CJ?
Well, we are already in the West African court, and they are even adjourned for some interim measures to be given before they were faced with this fait accompli of the committee having, presented these recommendations, and the president had quickly and with an indecent, removed it. That is also still there, which is pending. There are other cases, the Supreme Court, you do recall that in one of the rulings, Amadou Tanko JSC, who gave that lead to Secretary, said that the substantive matter is pending, and that issue is for peace. Some of the things is asking in the interlocutory in this application would be taken care of. If you read the entire ruling, you'll find that. So that is also pending.
I'm grateful to you. Nia Ikwetu is a former Attorney General and a lead lawyer for the CJ during the Gabriel Pwamang Committee hearings. Let's now bring in Godwin Edwiji Tamaklo. He's Director, Legal Directorate of the NDC. I'm grateful to you, sir, for joining here. Now, doesn't the former CJ have cause when she says one of the reasons that you've stood on to find misconduct in terms of expenditure? On that particular case, I have not that expenditure has not even been disallowed by the Auditor General, and therefore you cannot then use it as ground to remove me as a CJ.
Okay, so once again, good evening. Good evening to my learned senior, the Honorable Ayukwe. I think the preliminary matter that we need to first address. A committee set up Article 146. Is it after it has concluded its work to the remedies available in judicial review? I think it's the first question that we need to ask. Until we find an answer to that question, it becomes extremely difficult to proceed. Let me say this. The nature of the Article 146 committee and its work is sui generis. It is only known to the 1992 Constitution without more. Its workings and everything is supposed to be confined. So you notice that even the composition of that committee is dictated by the Constitution itself. Now, where the Constitution intends that the working, the findings of a committee should be subject to a further probe, the Constitution has always expressly made that clear. So, for instance,
sorry.
No,
okay.
1 minute.
All right. Yeah.
1 minute. If you look at the Constitution, relative to, say, commissions of inquiry, it says a person dissatisfied with the work of that commission of inquiry has a right of appeal, which right the Constitution tells you where you can vindicate that right, the forum you can go. Why were the framers of the Constitution silent? Because obviously they would envisage that not everybody will be pleased with the outcome of the workings of the commission set up under Article 146. And it's fine. You see, this is not like the commission is working and you are challenging maybe a decision taken in the... This is a commission that has concluded its work, submitted its findings, and based on those findings, the president has acted.
So is it lawyer, sorry, is it your argument that once their work has been completed, then one cannot challenge the decisions they've arrived at?
You see, when the Constitution wants to challenge an outcome of a body, it tells you where you can do. Where in this case, the committee has finished its work, submitted it, the president has acted on it. Like I gave you the example, the commissions of inquiry. Mm-hmm. So, for instance, I gave an example, Brazil commissions of inquiry, Ghana, all of those things. The Constitution says if you are not happy with this work, this is what you can do. How come that the framers of the Constitution were silent in an Article 146 committee? Now, the question and the challenge here is that, and that is, in order not to avoid a constitutional crisis, the framers left everything where it is. The president should act. The president has acted. Not only that, he had proceeded in making a fresh appointment. Then you come out with it. The question to ask is it the case that the framers of the 1992 Constitution, to avoid this, left the fact that no other thing flows from here? It ends. In the sense that, is this a disguised appeal closed as a judicial review? Remember that the committee under 146 and its working is supposed to be confidential. Now, if you permit a disguised appeal closed as a judicial review, the end result is to undermine that confidentiality, where in this case you permit somebody to put otherwise things that were supposed to be confidential in the public domain in the name of asserting a judicial review remedy.
All right. Lawyer, I'm grateful to you. Let me bring in Kweku Ansah now. He's former director, Ghana School of Law. I'm grateful to you for joining here. I want to understand, when the committee is done with its work, can the person involved challenge it if he or she feels that there's been a wrongdoing somewhere?
No, not at all. So I agree with the last speaker. He, puts, the matter right. You see, the framers of the Constitution didn't, create any window of opportunity, for a challenge. No such, route was created. So I agree with him. But the other question, can't we find, a way out? No. My answer is simple, a straightforward no. If in the wisdom of the framers of the Constitution, a challenge could have been entertained, they would have created, another clause. So perhaps, we wouldn't have had 146. It would have continued in many more avenues. So, as far as the CJ removal process is concerned, the moment the president, acts in accordance with the Constitution upon the findings and recommendations of the committee, the case should, be considered closed.
But
intents and purposes.
Isn't that why we have the Supreme Court, such that if someone feels there is an unconstitutionality in the conclusion the committee has arrived at, then the law would have to be interpreted by the people who understand the law, not so?
Yeah, sure, but it is not in every case that the framers of the Constitution try to constitutional lawlessness or crisis in the country. So if you look at the modus operandi of Article 146, it begins, with, acknowledgement of a petition. So you read Article 125, clauses 1 and 2, in conjunction with Article 146, and you see that the framers of the Constitution aligned citizens' participation in the judicial process in initiating petitions for the removal, of the Chief Justice. In the case of the President, you see a different process. So let us restrict ourselves, to Article 146.
Okay.
I am submitting that nowhere in Article 146 is there room, to challenge the final decision. So once the President makes, a decision on the findings and recommendations of, any such committee, we have come to the end of the road. So no one, can open the President, under the Constitution, the key is not, left hanging on top of the door. No, it's being taken away, and therefore there is no key with which to open and enter.
Okay.
That is the position of the law.
So based on the premise you've built, there's much ado about nothing on in this particular case.
Apologies to Shakespeare.
Grateful to you, sir, for your time here. Kwanzaa Asare is former director, Ghana School of Law. And that's how we conclude the story for you, brought to you always by Telecel Connecting Energies and also by, I'm told that we have Nia Iko to back on that. The top story is brought to you by Telecel Connecting Energies and also by Assured Pension Trust into the future with you.